and I am going to share my screen and get started. Okay, so today we're going to talk about updating housing protections for victim survivors of the gender-based violence at the Colorado level. There are some different laws that apply to folks in federally subsidized housing under the Violence Against Women Act. We're not going to get into those specific protections today. We're just going to talk about state level laws. So the Colorado Poverty Law Project is a nonprofit, and we support tenants throughout Colorado. And our mission is to prevent homelessness through legal representation, education, and advocacy. And we do that because we believe no one should become unhoused for lack of access to housing justice. So we offer pro bono legal services, community education, policy advocacy, all toward the aim of housing justice for all Colorado tenants. Our Gender Advocacy and Housing Initiative is one of our newest initiatives. And the initiative provides holistic advocacy for tenant victim survivors of domestic and sexual violence, stalking, and unlawful sexual behavior. That comes through mostly direct legal representation for tenants. If they have lease breaks, again, VAWA issues in the federal level, eviction defense, discrimination, or retaliation. We have some limited client assistance funding for housing-related expenses, only in Adams County. That's the only county we have funding in, but it can be used for hotel stays, back rent to avoid an eviction, future rent at a new home, moving, storage, anything that would enable a victim survivor to either maintain safe housing or leave unsafe housing for safer, more stable housing. We do that also with our housing navigator, who is an excellent kind of wraparound service provider and trauma-informed advocate. And we do presentations like this. We do community education and advocacy, and we really enjoy being out in the community and hearing from you all on the ground about what's going on. Okay, so I'm a lawyer, so you're going to get a disclaimer. This presentation is not legal advice. It just provides general information about Colorado housing law. And so it's not specific to any case or situation or client, and it doesn't create an attorney-client privilege between viewers and CPLP. If you do have a specific question about a client that you're working with or a specific situation that you'd like to discuss, please contact an attorney. Our contact information will be at the end of the presentation. Okay, so we're going to start by talking about House Bill 25-1168. As Kathy mentioned, that is the bill that brings us here today, and that is the source of the protections that we're going to talk about. And then we will break that down into the bill's sort of individual parts, and we will run through them at kind of a high level. So again, like Kathy said, please do interrupt, put the question in the chat, and then we will try to get to questions as they come up. And we should have some good time for questions at the end. So please ask. Okay. So I also am thrilled to have a member of Representative Espinoza's staff here. Representative Espinoza, along with Representative Lindsay and Senator Weissman, were our prime sponsors for HB 25-1168. And obviously, we would not have accomplished these expanded protections without each of our sponsors, and also not without the incredible support of CCASA, among other incredible community partners. But it was really a team effort, and we're really proud of the coalition that got this across the finish line. So the bill was signed into law on May 22nd, 2025, and all provisions of the bill are effective as of today. Many of them, the vast majority, did go into effect in May. There were a couple of sort of small pieces of the eviction process reforms that went into effect in August. But everything we're going to talk about today is active law, and at this point has been for some time. So we had a couple of sort of overarching goals for this bill. One, obviously, was to strengthen the protections that folks who experience gender-based violence and live in rented housing in Colorado have. But we also had identified, in addition to the gaps in the legal protections, some different treatments of the law from the landlord-tenant side, like lease breaks and things like that, versus the eviction code. So there were different kinds of behavior that, if someone had experienced them, would qualify them for protections on the landlord-tenant side versus the eviction side. So a tenant could break their lease early, for example, after they experienced domestic violence, domestic abuse, unlawful sexual behavior, and stalking. But on the eviction side, victim survivors were only eligible to raise eviction defenses if they had experienced domestic violence or domestic abuse. And so the eviction code really left out a lot of folks who had experienced sexual violence and stalking. And so one of our goals was to kind of level up the kinds of behaviors that made folks eligible for these legal protections. So when we say gender-based violence in the context of this bill, we're talking domestic violence, domestic abuse, unlawful sexual behavior, and stalking. So all four of those behaviors are now treated the same throughout eviction and landlord-tenant law. So the same protections apply for all four across all issues of housing law. We also wanted to make sure to include not only the criminal definitions for these acts, but where possible, the civil definitions from the Civil Protection Order bill that was passed, maybe the session before this past one, but recently, because we wanted to underscore that these behaviors are often not just isolated criminal incidents, but often are, those patterns of behavior that might not rise to the level of criminal behavior, but still are incredibly disruptive and harmful to victim survivors' housing stability. So that was our first goal. Our second goal was also to kind of standardize what kind of documentation tenants need to provide to trigger these protections. Again, landlord-tenant law had 3 options. Eviction law had 2 options. They didn't totally align. It caused a lot of confusion. So again, just standardizing that documentation requirement across all housing issues. So for all of the protections that we're going to talk about today, these 4 options apply. So when I say provide documentation of gender-based violence, I'm talking about these 4 options. And a victim survivor can provide any one of the following options. The first is a police report. It does need to be from the prior 120 days for landlord-tenant laws like lease breaks, security deposits, physical safety modifications that we'll talk about, but there's no time limit on that police report for an eviction defense. You can also provide a valid civil, criminal, or emergency protection or restraining order. Again, there's no timeline on that. It just needs to be in effect, so it can be temporary or permanent. We're excited about this one. This is a new option for Colorado tenants that we did borrow from VAWA, from the federal housing law. And it's a self-attestation statement that allows the tenant to self-attest to the abuse that they're facing. We know that often victim survivors are not able to reach out to the police or use the protection order process in court, or even reach out to a qualified third party, which we'll get into in a minute. But we really wanted this to be responsive to the kinds of circumstances that victim survivors find themselves in the kind of aftermath of experiencing this kind of violence. So that statement needs to state that the tenant has experienced unlawful sexual behavior, stalking, domestic violence, or domestic abuse, and that experiencing that violence is the cause of, contributed to, or resulted in the alleged reason for eviction or lease break or other landlord protection. The statement does need to include the name of the perpetrator if it's known to the victim survivor and the victim survivor feels it's safe to do so. If they don't know it or if they don't feel that it's safe, it's always a good idea to include that. If a landlord receives conflicting self-attestation statements from multiple tenants, only then can the landlord ask for a letter from a qualified third party to sort of substantiate that self-attestation. If there's no other self-attestation statement made by another tenant, the landlord is not entitled to ask for additional information from a victim survivor. And then I know we have a lot of service providers on the call today, which is wonderful. And many of you might have been familiar with the law that required a letter to be written by an application assistant from the address confidentiality program. That is no longer explicitly the rule. I think many of the folks that are covered by qualified third party will be application assistants, but we were hearing from a lot of tenants that they didn't know what that was or how to access it, and landlords were being quite strict about it. And so we just, again, wanted to make it a little bit easier, lower those barriers to getting the kind of support that victim survivors need. And so now it just needs to be a qualified third party who can attest to the abuse and its connection to the housing issue. That can include folks who work at a victim survivor service provider, an attorney, a social worker, a licensed medical professional. And I want to note here that the law before 1168 required that medical professional to be licensed in Colorado. Now it can be a licensed medical professional from any state, because we know that sometimes it's important for a victim survivor to leave Colorado, but then they could still be facing eviction. They could still be needing to terminate a lease contract, and they've sought medical care outside of Colorado. So again, making it a little bit more responsive to what victim survivors go through. And then also faith leaders or mental health providers, and this is not an exclusive list, but it is sort of representative of the kinds of folks that we expect to write these letters. Okay, so jumping into the substance of the law, the lease break process remains largely the same. The law before 1168 required a victim survivor to include written notice to a landlord of their intention to terminate their lease early without penalty, as well as written, evidence of the abuse, that documentation we talked about, and that still is how to break a lease, right? Written notification of the intent to break a lease and evidence of the abuse. Again, those 4 documentation options: police report, protection order, self-attestation statement, or qualified third-party letter. Probably it's best practice, right, to provide those 2 pieces to the landlord at the same time. But if the tenant seeks to break a lease and doesn't provide the required documentation at that time, the tenant has 7 days to provide that documentation to perfect that notice. But again, probably best practice to include it at the same time where possible. This was not explicit in the law. We certainly thought it applied, but we did want to clarify that a victim survivor can use this law to terminate their lease without penalty at any time, as long as a court had not entered an eviction judgment against the tenant. So that means that there could be a situation where a victim survivor faces an eviction notice, receives an eviction notice, and sort of starts the eviction process, but also needs to terminate their lease and move out, right, to protect themselves from having to be contractually bound for whatever reason to that lease or that home. And so we had some pushback from landlords who said, we've already started the eviction process by giving you this notice or by serving you with this lawsuit. You're not allowed to break your lease. You're only bound to the eviction process. And we clarified that a victim survivor can terminate their lease during the eviction process as long as a judgment has not entered. Where we did make pretty substantial changes is the what money could be owed to the landlord after an early termination and how a landlord can go about getting that money from the victim survivor. So when we're talking about money owed to the landlord, we're talking about future rent after the termination. This section of the law does not address back rent that might have come due prior to the lease break. That debt would not be impacted. We're talking about future rent charges after termination. So as before, it's possible that a victim survivor could be responsible for up to 1 month's rent after they vacate the property. But now the landlord has to document that they have actually suffered an economic loss directly due to the victim survivor's early lease break and provide a written statement of those damages to the tenant within 30 days of termination of the agreement. So failure to provide that written notice, that kind of receipt of what money was needed to be spent, what kind of money was lost, kind of economic harm that the landlord experienced within 30 days. And if they don't, then they're not allowed to collect any future rent post-lease break. This is similar to a security deposit return, where if a landlord doesn't follow the security deposit return law to say, this is the damage done to the apartment, this is what I'm taking from your security deposit, within a certain time frame, they lose the ability to keep any part of the security deposit. It's the same logic there. You have to say what money this cost you in writing within 30 days, or you're not allowed to collect any future rent from the victim survivor. If the landlord can document those damages, the tenant has 90 days to pay, and the security deposit does not need to be returned until that up to 1 month's rent and damages has been paid. Really importantly, the law now says that if another tenant remains on the lease following the victim survivor's termination, the landlord is not allowed to collect that up to 1 month's rent from the victim survivor. That person can be any other tenant. It does not have to be the responsible party. It can be just another tenant, which feels logical and natural, right? Because the contract allows the landlord to collect rent from those people on the contract, and so charging the victim survivor future rent would be extra unfair. And I see chat messages, so I wonder if now's a good time to pause.
Yes, the first one is from Alexandra. Do you have examples of the proof of economic loss a landlord needs to provide?
Yeah.
Like, can they simply write loss for rent of empty unit, or do they need to provide something more specific or detailed?
It's a really good question. It's a question we get all the time. And the lawyer's answer, the classic lawyer's answer, is that it depends. This law does not sort of break down and enumerate what a landlord needs to have experienced to be able to charge rent, right? what is an economic damage? This law doesn't define. Generally, in sort of all contract law, there's a duty of someone who is on the sort of the non, if a party terminates a contract, the party on the other side has a duty to make sure their damages are as small as possible. And so the landlord can't generally say, well, I'm not going to do anything. I'm not going to post this apartment on Zillow or on Craigslist or whatever. I'm not going to advertise it at all. I'm just going to sit on this and I'm just going to collect 1 month's rent, right? You have to try to make sure that the economic losses are as small as possible. So if a landlord doesn't do anything and just says, I didn't have rent paid, but didn't do anything to try to get rent paid, that is probably an unreasonable thing to charge someone for, right? Because they didn't try to keep their damages as small as possible. It does need to be directly due to the victim survivor's early termination. So if they do rent the apartment, right, but the apartment is way overpriced, right, or if it's not well maintained and if it's just not somewhere where someone wants to rent, that is not directly due, in my mind, it's not directly due to the victim survivor's termination. It's also due to the condition that the apartment has been maintained or whatever the reason is. So they don't really need to provide a ton of documentation, but it's, again, I think it's useful to think about the security deposit law where it just needs to say like, well, I had to pay $50 to post this apartment, so you owe me $50. Also, you know, I lost because I posted it, and I tried to rent it out, but I couldn't. You also owe me, you know, the 1 month's rent, but it has to be capped at 1 month's rent. So it's not 1 month's rent plus that $50 posting fee. It would be inclusive. Does that answer your question?
She says that helps a lot. Thank you.
Okay, you're welcome. We get that question a lot, Alexandra. So
I bet. Mary has a question. Who does the documentation about harm to the landlord go to? Is it provided to the victim or to the courts?
The victim survivor tenant. Generally, in a lease break process, we're outside of court, and so it goes to the tenant. And again, the same way that a security deposit would go directly to the tenant. Generally, it's the last known address. So a victim survivor should provide an address if it's safe, you know, to get mail at after they leave. But yeah, it goes directly to the tenant.
Great.
Any more questions on this, on what a landlord can charge for?
I don't see any right now.
Okay. So we were seeing a lot of lease break situations where a victim survivor had provided written notice and documentation of what they experienced, and they told their landlord they were terminating the lease. They moved out, they complied, and they didn't hear anything from their landlord. And then 6 months later, they got a bill for $15,000, right, of unpaid rent. Or all of a sudden, this showed up on their credit score, right, their credit report, that they had this big debt that the landlord just sent to collections. So now the landlord is not allowed to assign any alleged debt to a third party unless they first follow the procedure that we just talked about, right? Providing written documentation of damages within 30 days and providing an additional 90 days written notice that they intend to send the debt to collections. The notice can be provided through any means of communication that the tenant has requested. And if they haven't requested anything specific, notice through the last known electronic contact information, which most people would call email, is sort of the default there. If the tenant cures or pays what they owe within that 90-day notice window, they're not allowed to pursue the collection action. And again, this is only the debt that is following the termination. If there's back debt that the tenant owes, that debt can be sent to collections outside of this process, or handled in a money suit or other kind of sort of debt collection action. But this is all to do with rent that the landlord could try to charge the victim survivor following that early termination.
Ariane, Holly has a question. Damages equals financial loss?
Yes, thank you. Damages is, financial loss. It's money that has been incurred, money loss that has been incurred due to some sort of action. Thank you for clarifying that lawyer speak. Okay. You see a lot of yellow on this screen because this is a lot of new information. So what happens when you break your lease early? What happens to your security deposit? So now there is a presumption that if the responsible party is a party to the lease along with the victim survivor, first of all, the victim survivor is only breaking their tenancy, right? The lease contract survives, and the responsible party in this situation would remain a party to the contract and responsible again for the rent and for the liability under the lease. But there is a presumption that the victim survivor would receive the full security deposit at the end of their tenancy, less any lawfully withheld amount, which again would go beyond normal wear and tear. The presumption does not mean it's 100%. It means that that is the default, and unless there's sort of extenuating circumstances, that would be what should happen. We haven't seen this play out that much yet, so I don't have a ton of answers about what this will look like, but that is the goal, is to get the victim survivor that security deposit back when they break their lease. Another new provision is that a landlord is not allowed to deduct any damage to the unit that has happened because of gender-based violence from a victim survivor security deposit. They also can't charge a victim survivor to fix damage in the unit, even if they're not breaking their lease, right, because of gender-based violence. The landlord can only seek compensation from the responsible party. So we've had a lot of questions about, like, well, what if I don't know, right? What if it was a break-in, it was a stranger? That would make it more difficult for the landlord to recover that money, but it does not mean that they can pursue the victim survivor for it. And so might that be a little bit difficult for the landlord? Potentially. The point is, the victim survivor is not responsible for damage that has been done because of gender-based violence. All right. Landlords are not allowed to evict a tenant solely because they've experienced domestic abuse, domestic violence, unlawful sexual behavior, or stalking. They can't impose a penalty on, retaliate, or ask tenants to waive their right to or prevent victim survivors or folks on their behalf from calling for emergency response for situations involving gender-based violence. Landlords cannot inquire about, consider, or require disclosure of any information from an application regarding the applicant's status of a victim survivor, a status as a victim survivor, or experience with gender-based violence. Sometimes we had seen landlords give a negative reference to a future landlord because they had broken their lease early because of experiencing gender-based violence. So we made that explicit that you can't do that. And then sort of tying into that, we put some really important guardrails on what information a landlord is allowed to share outside the victim survivor. So a landlord cannot disclose the victim survivor's new address, information about the lease break, or anything about the victim survivor's experience with gender-based violence, even to a co-tenant, without the tenant's express written consent or pursuant to a court order. So before, this confidentiality provision said the landlord is not allowed to share any information with anyone unless the landlord feels they need to comply with some law. That is a loophole that's so big, you could drive all the cars in the world through it, right? And so we wanted to really bring that in, because what we saw a lot was the landlord share the lease break information with the co-tenant, who in some cases was the abusive party. We know that when victim survivors are trying to leave, can be the most dangerous point in an abusive relationship. And so we wanted to really make sure that landlords were not sharing information, even with the co-tenant, unless the victim survivor said it was okay, or there was some sort of court order, which probably would take the form of perhaps like a subpoena to show, why a victim survivor terminated their lease. It's very, very, very rare and unlikely that the court order would kick in, but that's one of the options. We don't want landlords to incur liability, right, if they're being asked to share information from a court. The co-tenant piece, though, is important, because the landlord would say to us, well, it's contract law. I have to let this person know why they're responsible for the whole contract. And we disagreed, and so did the legislature. And so now, unless a victim survivor provides written consent, the landlord is not allowed to share information even with the co-tenant.
Ariane, we have a question from Alice in the chat, and she asks, if a landlord is not following these laws and giving the survivors a lot of pushback, what should the survivor do? Would the survivor need to get an attorney and fight in court?
Maybe. We'll talk about what to do when landlords break these laws in like 2 slides, but I like the way you're thinking. You're thinking like a lawyer. Okay, so before 1168, Colorado law didn't have any specific protections for victim survivors to make physical safety modifications to their home following gender-based violence. So again, following documentation of gender-based violence, the landlord cannot prevent a tenant from changing locks, or charge the tenant for changing locks, or otherwise prohibit or retaliate against the tenant for changing the locks. The tenant needs to make reasonable efforts to provide the landlord with that new key or access code, if it's one of those digital keypads, as soon as it's reasonably necessary, but not later than 14 days after the locks have been changed. Unfortunately, we've seen a lot of cases where the landlord or the maintenance manager or someone in a landlord capacity is the abusive party. And so we wanted to address what happens in that situation, because there are situations where the landlord, the property manager, needs to get into the apartment, right? If there's an emergency or if there's a repair that needs to be made. So if the landlord, property manager, or owner is the responsible party, the tenant has to make, again, reasonable efforts to provide that new key or access code to another person whom the victim survivor deems is safe, with the authority to manage the property, as long as that person agrees not to share that key or code with the responsible party. So again, recognizing that sometimes landlords or property managers need to get in and have an interest in getting into their own property if it's the owner, right? But doing everything possible to keep the victim survivor safe. And so finding an alternate way to get into the apartment, right? If something needs to, if someone with landlord privileges needs to get in while keeping the victim survivor safe. The landlord also cannot prevent the tenant from taking reasonable safety precautions and making what we call non-permanent modifications. So things like window bars or cameras, installing a security system, additional lighting outside, as long as it's not a permanent modification, as long as the tenant isn't permanently changing the structure, the landlord can't prevent or charge a fee for that kind of modification. And those changes cannot be considered a material or substantial lease violation that could lead to an eviction. The landlord also needs to take all steps reasonably necessary to respond to a tenant's safety concerns. So, for example, if the front door of a building doesn't lock or windows are easily opened from the outside, for example, that might violate another part of the law. But under this law, the landlord is sort of doubly required to respond to that kind of specific safety concern from the victim survivor, again, after receiving documentation of the abuse. Okay, so what happens if the landlord breaks the rules? Before this law, there was really nothing, right? So Alice, if you would ask me that question in April, I would have had a very different answer, which is to say you could try to write a demand letter or do something to explain to the landlord that their behavior is wrong and they are breaking it, but there wasn't necessarily a lot of teeth behind it, right? There weren't really enforcement mechanisms to make sure that the landlords were following these rules. And that was a problem for the legislature. And so the legislature created a cause of action, a legal reason that tenants can sue their landlords to prevent any future violations of these rules and to be compensated for past harm. So if a tenant believes that their landlord has violated anything we've talked about so far, they can file a lawsuit to recover actual damages, what those violations have cost the victim survivor, and that could be a variety of things, court costs and filing fees, the victim survivor's attorney fees, and if the court finds that a violation of these laws has occurred, the landlord is required to pay at least either 3 times the monthly rent or $5,000, whichever figure is higher per violation. This is a unique remedy, but the legislature has also allowed tenants to seek what we call punitive damages for violating these laws. And punitive damages are just what they sound like, right? They are to punish bad behavior. There are sort of other criteria that need to be met in order for a court to award punitive damages. But I think the legislature's inclusion of this, ability to seek punitive damages shows how seriously the legislature takes this issue and how important it is that landlords do follow these rules, follow this law, which is designed to keep victim survivors safe and housed following gender-based violence. So yes, I would talk to a lawyer if a landlord has violated these rules. We're going to move into the eviction process now. So I do want to pause to see if there are questions about what we've talked about at this point before we move on. Obviously, there's a chance to ask questions again, but Okay.
I don't see any.
Thanks, Kathy. So evictions. Evictions are skyrocketing throughout Colorado, and we're seeing folks facing evictions for what we would call behavioral lease violations, primarily, by far, north of 95% probably. The most common eviction is a non-payment eviction. And so we wanted to address the way the eviction process, well, generally maybe not super friendly to tenants, was extra unfair to folks who were sort of dealing with the aftermath of gender-based violence. So we made some changes. Again, before 1168, unlawful sexual behavior and stalking were not valid reasons that you could raise a defense to an eviction. Now they are. So unlawful sexual behavior, stalking, domestic violence, and domestic abuse qualify as defenses to evictions for non-payment of rent. Is, again, a really important addition. We know that victim survivors often face economic abuse. Abusers interfere with employment, sometimes do take money directly from the victim survivor, ruin their credit, just a variety of coercive and manipulative tactics as part of the abuse. Sometimes you can't work following abuse, right? And so it was really important to us to make sure that non-payment of rent was something that we could address in the wake of gender-based violence. You can also raise gender-based violence defenses to substantial violations, which are sort of specific, dangerous criminal actions. Material violations of a lease, which is like if you violate a very important part of the lease. Repeat violations, or a nuisance is sort of a new kind of eviction from the just cause eviction bill. But gender-based violence is explicitly not a nuisance under that law. Again, to raise these defenses, you must provide corroborating evidence. It needs to, again, it can be a police report from whenever, a valid protection order, a self-attestation statement, or a written statement from a qualified third party. We are seeing, I think, the majority of folks that I've seen, especially in like our courthouse clinics, have been using self-attestation statements primarily. And we've seen some pushback, both from the bench and from the landlord bar, that a self-attestation statement that just says, I've experienced gender-based violence, it is the cause of the eviction, or contributed to the cause for the eviction. The names of the responsible party, the name of the responsible party is X, or I don't feel safe providing it, and then a signature. We've gotten a lot of pushback that that is not sufficient. However, we've won those cases because the law is very clear that nothing else is required in order to substantiate what happened. The whole point is to not interrogate a victim survivor about what happened. If the legislature wanted victim survivors to be interrogated or to be required to explain in more detail the connection between what happened and the alleged reason for eviction, they would have said so, but they did not. And so we have been successful in court making sure victim survivors don't have to disclose, intimate details and specific, long tales of what happened to them. Okay, I am going to very briefly just go through the eviction process. We can and have done, hour-long presentations on the eviction process. It's complicated and it's long. Well, it's actually quite short, but there's a lot of steps in it. So I'm just going to run through it at a very high level to kind of contextualize what has changed for victim survivors. The thing to take away from this timeline is that between step 1 and step 5, can be as short as about 6 weeks if the minimum timeframes are followed. So if you are experiencing any of this, or you know somebody who is, please get a lawyer involved as early in the process as possible. It's much more difficult for a lawyer to challenge something that's already, several steps down the line. I'll say it's never too late, but it is best to get involved as quickly as possible. So I'll take, so the first step, right, is the lease violation, something causing the eviction, whether that's unpaid rent or, a substantial violation. The landlord is required to give the tenant written notice that they have violated the lease. If the tenant receives what's called a notice to quit or a notice to terminate tenancy, notice means you don't have an opportunity to fix what's wrong. You'll see that for a repeat violation as well as a substantial violation. It means you are out. You have to be out in between 3 and 10 days. And then if you aren't, then step 2 kicks in. But for a demand, where you see it for the first violation of a lease or for non-payment, it's a demand for either compliance or possession. That's what the notice should be called. And that means you can fix it, right? A demand means give us the money that you owe us within 10 days and we're good. Or move out within 10 days and we're good. Change the behavior, get that grill off your patio or whatever the minor lease violation is within 10 days, we're fine. But again, the maximum amount of time on a demand is 30 days, and that's only for non-payment in a federally subsidized property. So generally, it's going to be 10 days. If the tenant does cure, right, within the demand time frame or vacates within the notice time frame, we end at step 1. That's all that can happen. No, we're not in court. Nothing happens. The lease is, tenancy is terminated and the tenant no longer lives there. No eviction. But if they don't, right, because between 3 and 30 days even is not a super long time to move out or collect money that you owe, that's when the landlord can involve the courts and file an eviction lawsuit, the complaint, and a summons to appear in court. These are really important papers, especially the summons tells you when your first court date is. And that takes to step 3, which is the return date. The time between step 2 and step 3 can be as short as 7 days. So 7 days, the tenant has to have at least 7 days from when they're served with the lawsuit to when they have to respond to the lawsuit. And they do that on the return date, the date listed in the summons. The tenant needs to file an answer on that day. The answer lists, all of the legal defenses to the eviction, the lawful reasons why the landlord is not entitled to evict them. A tenant can file a counterclaim, which is suing their landlord back. That's pretty rare, and I would advise folks to talk to a lawyer before they do that. You can also file a motion to dismiss the case if you believe there's no valid legal basis for the eviction, or a tenant is free to sign a stipulation or a settlement with the landlord to resolve the case without going to trial. After a tenant files their answer, they have a statutory minimum of 7 to 10 days between answer and trial. Obviously, with the number of evictions that are being filed in Colorado, some courts are having to set cases out beyond that 7 to 10 day window. But again, the minimum that it could be is 7 days after you file an answer. And then at the trial is the most common time where the court would determine who's entitled to judgment, right? Is it the tenant? Did the landlord not meet their burden to evict the tenant? Then the case would be dismissed and the tenant would not have to move out. if the judge agrees with the landlord that the landlord did things correctly and the tenant hasn't proved their defenses, then judgment would enter. It's called a judgment for possession. It's not called an eviction judgment legally. And the writ of restitution is the piece of paper that would allow a sheriff to come do a move out of the tenant. Generally, that writ of restitution can be executed. A sheriff can move someone out of their home 10 days after a judgment has been entered. So again, super quick between step 1 and step 5. Sometimes it takes longer, but I think a lot of people think like, well, I'm being sued, I probably have, a couple of months, right? That is not true in an eviction. It moves incredibly quickly. And I will say a tenant can avoid an eviction judgment really anytime before step 5 if they move out, right? If they move out on their own, they can't be evicted by the court or by the sheriff. So that's always an option if someone has somewhere to go. But of course, that can be a tricky needle to thread in any situation, especially when dealing with gender-based violence. So we tried to build in some protections kind of at each stage of the eviction process. So the demand for rent, that piece of paper that says you're late on rent and you have 10 days to pay it or 30 days to pay it, depending. And the summons for all eviction cases has to include a statement about the availability of a potential payment plan, which we'll talk about in a minute, and the documentation options that would entitle a tenant to that payment plan. And then there are requirements for how a landlord delivers these papers to a tenant, right? So in standard eviction cases, a landlord has to make 2 attempts at personal service on 2 different days. Personal service just means like handing it physically to the person whose name is on the papers. And if they can't do it then they can post the demand on the door. Posting demands on the door is like a neon arrow to both identify that this person lives here, because it has to have their name and the address, and is a signal that they're facing some sort of difficulty, right? Some sort of vulnerability. And so that is very unsafe for people who are experiencing or trying to avoid, right, gender-based violence, because we know that abusers often kind of weaponize housing instability or economic instability as a way to kind of get further in and perpetuate that abuse. So if a landlord has received that written documentation, right, the 4 options, they need to make all reasonable efforts to personally serve that demand. If they can't personally serve within 3 attempts, the landlord can serve through certified mail or, UPS or FedEx or, whatever commercial carrier that has a receipt or proof of delivery. Again, we just don't want that demand up there on the door for everybody to see. We know that sometimes abusers do go through mail, right? But we were just trying to make it a little bit safer, right? A little bit less obvious that the tenant is experiencing potential eviction. So once an eviction case is filed, it is suppressed, meaning it's only public, it's only viewable by the parties to the case, the landlord and the tenant, and the court. If a judgment enters against a tenant, those records become unsuppressed or public, and that's how they show up on a tenant screening report, which can also be, again, quite unsafe for a victim survivor. It can prevent you from getting into housing in Colorado for 7 years. That's a lawful reason for a landlord to deny an applicant. But it also, again, can show, it's the same thing as posting on the door, right? It's public information that the victim survivor is experiencing some sort of difficulty that could make them more vulnerable to further abuse. So now, as long as the tenant files a motion providing the accompanying documentation of gender-based violence and a statement that public access to the eviction file poses a danger to the tenant or their family member, the court is required to resuppress it. And this goes back, the language of the law says, any judgment prior to the effective date of this section, right? So we have successfully been able to suppress eviction records for victim survivors going back years, which has been helpful in getting them into new housing and things like that. So that's a really important tool. Before this law, you'd have to ask the landlord, whose judgment, right, whose case it was, to suppress it, and they were not required to do that. And many of them wouldn't do that, even if you explained what was going on. So now the court is required to resuppress the file upon a tenant's motion. So we think that's very important. Providing documentation of gender-based violence is automatically good cause to set aside a default judgment. If you don't file an answer by your return date, for example, you miss a court date because you don't have access to a car, you don't have access to the internet, you're not physically able to make it to court, right? Whatever the reason is connected to gender-based violence, if you miss a court date, you can get that judgment undone with the opportunity to, answer or appear again. Courts are also required to allow a victim survivor to amend or change pleadings that have already been filed and file additional pleadings, which is not guaranteed in county court where most evictions are, as well as to extend a scheduled trial date or get a continuance. Any of the four documentation options we talked about can get those protections for a victim survivor. The court is required to grant those motions. And then finally, a tenant who has provided documentation of gender-based violence and still gets evicted, right, cannot be moved out by the sheriff for 30 days following the entrance of the eviction judgment. So up from 10 days, we know that 30 days isn't a ton of time, but it's more than 10 days, right? It's a little bit more reasonable for folks who have experienced gender-based violence. And the last thing we're going to talk about is what happens in a non-payment eviction, right? It's important to know that experiencing gender-based violence is not going to get a victim survivor out of having to pay the rent that they owe. It doesn't dismiss the case full on to say, I've experienced gender-based violence, and so you can't evict me at all. Because, there is still an interest, right? I mean, there's a contract in place. The landlord does expect the rent. The tenant did, sign a contract to pay the rent. But this is a situation that the legislature has realized is, unique and requires a little bit more time, a little bit more understanding and flexibility, while still providing an opportunity for the landlord to receive the rent that they are entitled to. You do that through a payment plan. So once a tenant submits documentation of gender-based violence to their landlord, the landlord is required to offer a payment plan to the tenant. If they don't offer a payment plan, that can be the kind of defense that gets an eviction case dismissed. So the way this works is, there's late rent or anticipated late rent and documentation to the landlord. The landlord then offers a payment plan no later than 3 business days after receiving the documentation or serving a demand with, again, that statement that a payment plan is available, whichever date is later. And then the tenant has 7 calendar days to accept the landlord's offer or propose their own plan, but it has to be done within 7 days. A tenant's failure to accept or counter within that 7 calendar days means they can't bring up the defense that the landlord didn't offer the plan in time, and it could endanger their ability to have a payment plan at all. If you're in an eviction case, you would file the payment plan with the court. You do not need to have an active legal eviction case to be eligible for a payment plan, but often we do see that. And then the tenant the tenant has to pay all delinquent rent, all rent that it has become due to that date, and any rent that comes due under the contract, under the lease, monthly rent payments, within 9 months. So what does that actually look like? There are some terms that the legislature included that should be included in every payment plan, right? The first is really important. The first is that no eviction judgment can enter while the payment plan is sort of open, unless the tenant defaults. We'll talk about that. This is important because this is essentially a settlement agreement, right? And most settlement agreements that we see landlords offer to tenants allows an eviction judgment to enter against the tenant as kind of an insurance policy for their performance of what they agreed to do under the plan. And then even if the tenant complies with the agreement, there are still steps that the tenant has to take to get that judgment removed. And so we just wanted to, again, eliminate that piece. It's a non-judgment settlement. So a judgment cannot enter while the payment plan is active. The tenant can select the due dates of each monthly payment and the amount of their monthly payment, as long as it's at least $25 per month and all lawfully owed rent is fully repaid within 9 months. That 9 months is important. We have seen some cases where landlords have said, well, your lease ends in 4 months, so we're just going to give you 4 months to pay. Even if the contract ends before 9 months is up, tenants are entitled to 9 months to pay that off. And landlords can't charge any fees, interest, or penalties associated with the payment plan. So if you pay your monthly rent late, right, it's likely that a landlord is able to charge a late fee on your late rent. There is no option for a landlord to charge a late fee on a payment plan payment. So the tenant could default, though, on this plan if they just don't make a payment, right? If there's no payment, they don't make a payment before the next due date, or they make 3 or more monthly payments at least 10 days late. If that happens, the landlord can serve a notice of default demanding that all rent under the payment plan is due within 7 days. And if the tenant pays in 7 days, great, we're good. But if they don't pay within those 7 days, the landlord is able to file a motion seeking that eviction judgment based on the tenant not following the payment plan. The tenant can raise any defense that would be available in an eviction case, like they didn't actually give me 7 days. I never actually got a notice of default. And then it's up to the court. Now, this is only in the case of an active eviction lawsuit. So if the payment plan is going on outside of an eviction lawsuit, and it's just a separate kind of freestanding contract, and the landlord wants to evict based on missed payment plan payments, they need to start all the way over. Step 1, notice of a demand for rent, wait at least between 10 and 30 days, file the lawsuit, do all those steps. But if it's within the active eviction case, they can file a motion within that case to the court. And I know that that gets a little confusing, but luckily that is all I have. So we have some time for questions. Please reach out if you or someone that you're working with is experiencing these issues. This is our intake form. You can fill that out on behalf of a victim survivor, or the victim survivor can fill it out themselves. Our intake team tries to get back to folks within 48 hours of filling out an intake form in some way, either connecting them to an attorney or talking to them themselves. So please do reach out if you have questions on any of this. Thank you so much.
There was a question earlier that asked, what type of sanctions have you seen as a result of punitive damages? And I believe you asked that, but just to make sure.
Yeah. We haven't seen them in this context. I think litigation will start happening now that the law is kind of out there and we're working under it. So I don't have any examples under this specific law, but in other cases, punitive damages can be incredibly high, right? They can be just a lot of money that, you know, again, there's criteria that you have to meet to be able to ask for punitive damages. The baseline is, does the statute allow for it? And then, you know, there are other, you know, there has to be willful bad behavior and, you know, a lot there. But generally, the idea of punitive damages is that it's a lot of money. I don't know if that answers the question, but.
And then Holly asked, can you share housing legal resource for survivors?
Yes. Well, we can share the Colorado Poverty Law Project. We can provide legal support for folks. Is that what you mean? Or are you looking for like more? I can share with Kathy to share out, you know, a guide for sort of handling these cases and sort of just kind of a quick guide to the bill. We can provide that as well.
Holly, does that answer your question? And we also have a companion question from Deidre that asks about legal resources on the Western Slope.
We take cases on the Western Slope. We can help tenants throughout the state. We do also have, you know, Colorado Legal Services is another wonderful partner of ours who provides pro bono legal support to tenants. CLS has more. We don't have any kind of income requirements or restrictions. CLS does. So that's for low income tenants, but they're an excellent resource as well, and they're statewide as well. In terms of specific to the Western Slope, I'm not aware of any legal resources in that region, but again, we're statewide, they're statewide, so there are lawyers available in those areas.
Great. Well, and I'm going to put the evaluation here in the chat, and you'll also get it in the follow-up email. And feel free to pop any other questions in the chat box. But Ariane, this is great. There are a lot of thank yous in the chat box. Really appreciate it.
I'm glad. I know it's a lot of, it's a big bill. It's a really big bill. So I know that there's a lot in there and a lot of sort of technical information. So I'm very happy to answer questions if they exist.
It looked like it did a lot of cleanup.
Yes. Yeah, we pretty much went through the eviction code and landlord tenant, you know, the landlord tenant provisions and redline them all.
Great. Okay, well, thank you all for attending, and thank you, Ariane, and we appreciate all of your time.
Thanks, Kathy. Thank you all.
Take care.